that, sorry, we're recording, I apologize. So the tale of two programs. We've got what we call retirement survivors and disability insurance, which is commonly referred to as Title II. And we have supplemental security income, which is Title 16 or SSI. So that it's a lot of stuff, but really breaking down the difference between the two programs is that the first, the RSDI, the RIB, the DIB, the Title II, whatever you want to call it, whatever you're covering, is that it's an insurance. So this is what you see that you pay in on your paycheck every time you're paying these taxes. Your employer is paying towards these taxes. So as you do that, you become insured through this program, and it covers retirement, disability, and survivors insurance. People who don't have the ability to work or haven't had a sustained work history aren't going to qualify for that benefit. But we do have a means tested benefit that tries to come in and provide a somewhat livable income for those individuals who aren't capable of a sustained of working or having a sustained work history. And that's what SSI does. So for RSDI to qualify, you have to have paid into the system, so you must be insured. That is usually working 40 quarters, or you might be eligible on a family member's, which is most often is a spouse or a disabled child. You can, so that's the first eligibility rule, but then it can be, to get paid out, you can either be retired, disabled, or a dependent. So, and it has different eligibility rules that is not as relevant to the overpayment system. What happens is, once someone has an overpayment, they have already been found to be insured or entitled if their overpayment is through the Title II program. It has no means tested rules, so there are no resource limits or caps on certain things. There are some limits on earned income, but usually that's related to either being in retirement status or being disabled. It's not something where they will reduce your benefits because you're earning. It just deals more with whether you're truly eligible for this benefit anymore if you're working a certain amount. So SSI is different, however. It has income limits. They will reduce your SSI income based on any earned income or unearned income you receive. And it also has asset limits, which requires that someone for an individual be under $2,000, which is very low. It also has a max benefit. The RSDI Title II program is based on how much you've paid into the system. It does cap out at a certain point, but it's a much higher benefit. SSI, the highest benefit an individual can receive in 2021 was $794. So that's what the two different programs are. And it's really important to understand which program someone is in. And oftentimes our clients don't know the difference, right? And they come to you and they're like, oh, I have an overpayment. And you ask them, well, is it retirement survivors and disability insurance or supplemental security income? And they will have never really heard. They're going to be like, it's disability. And you're going to be like, that's not helpful. So that, just a couple of tricks for learning, if a client's really not sure, is oftentimes if they're able, I ask them to read the top left-hand side of a notice, or you can review the top left-hand side of a notice. And that will tell you which program you are working under. Some individuals can actually live in both programs. So someone who maybe has a shorter work history and becomes disabled, or maybe becomes disabled earlier in life, they might receive RSDI, but it might only be, for instance, $500. And that's not the minimum benefit that you can receive in Social Security and supplemental security income. So then they would be eligible to apply for SSI to receive an additional amount up to the federal benefit rate, plus an additional $20, which we'll get into in a little while when we talk about budgeting for SSI income. So knowing what those two programs are is really the start. But these cases deal with people who have been already found eligible for those programs, but some eligibility factor has now been either missed or incorrectly computed. And the Social Security Administration is going to this recipient or claimant and saying, you owe us money back because you weren't entitled to that money. So they get an overpayment notice in that situation, telling them, or supposed to tell them at least, why they got that, and also how much they'll be withholding and for which period this is. So for Title II, which is the RSDI disability or retirement, there is no limit on withholding. And oftentimes they will attempt to take an entire benefit check for whatever length of time is necessary to repay an overpayment. And oftentimes, because these benefits are higher, these overpayments can be extremely high. We'll regularly get notices that say you will, that are very confusing, and say you will be paid in, for instance, April of 2023. What? Why am I not getting paid until April of 2023? And it won't be clear, but it will say that you have like a $40,000 overpayment. Well, those are the entire amount of checks needed to take and recoup in order to repay that entire overpayment. As you can imagine, that can be absolutely distressing to someone to think, okay, I have to live for 2 years without any benefits to pay back this overpayment. And this is why appeals and waivers are so important, to help individuals at the very least manage their repayment options. And oftentimes either oftentimes waive or correct the amount that there is owed. For Title 16 SSI, there is a cap on recoupment, and that cap is 10% of a check. So like this is, there are different amounts for each year. This year it would have been $79.40. It changes each year based on that cost of living adjustment to the SSI amount. And oftentimes we're looking in the past, so you have to look at these different things. So if they are not receiving benefits, so maybe someone, you've got these methods of recoupment while someone's in the program, but maybe someone not only got an overpayment, but they were terminated and they are no longer, and they truly are no longer eligible. There are still ways that Social Security can get their money back, as they are the government. And the most common way is through the Treasury offset program to repay through things such as your IRS tax return. So even for those who aren't receiving benefits, this can be really life-changing. They can also garnish your paycheck in certain situations. So these are, things that even for those who are no longer disabled, it can be really harsh recoupment methods for these overpayments. So the processes that we'll talk today not only try to change the amount of the overpayment or waive the overpayment, they also help you manage these recoupment methods. So just an overview, like I said, it's not today we can't go over every single way you can appeal or waive an overpayment, but I can give you some ideas of the most common ways and some of the most common tips and arguments to address these. So I've listed here, and I'll just pick a few out. For Title II, we have different concerns, right? Because SSI is a means tested benefit. It will often have different reasons for an overpayment than Title II. So probably the most common call we get for Title II overpayments is that an individual was disabled, but they, maybe had some improvement, or they felt like they could make a work attempt. So they've gone back to work and they've started working at a substantial gainful level. They have a period of time where they can do that without any consequence. But once they've passed that period of time, which is 9 months, they are not entitled to benefits in those months. So, and that is usually the most common thing. And we'll go over what SGA is, even though it, that's not a part of overpayment law, if you will. It's the eligibility factor that you have to understand to be able to resolve and assess the merits of the overpayment. That's probably the most common. The second most common is a continuing disability review. So maybe they haven't gone back to work, but every once in a while, depending on their disability, the Social Security Administration will review their medical need, right? So whether they remain disabled under the rules medically. So, and these often result in medical cessations, and during those appeals, people are entitled to continuing benefits because this is an entitlement and they are required to have due process, and they cannot lose those benefits during the appeal process. So if they've requested those continued benefits pending their reconsideration or their hearing, that can add up to quite a bit, especially with hearings being pushed out longer and longer, they can be pretty significant overpayments. But if they've, if they aren't successful, ultimately, they owe all that money back from the overpayment or from the appeal period, which can be really shocking to someone. But this is a really, actually, probably one of our easier resolutions, because as long as someone can show that they appealed in good faith, meaning they felt that they were still disabled and they attended the hearing and things of that nature, those will be waived under the regulations. So another one that we don't see as often is a workers' compensation offset. So there are some rules about offsetting this, and many times that just doesn't get reported adequately and they don't act on it appropriately. So that can happen. Someone who is receiving early retirement benefits, so someone over the age of 20 or 62, 22, if only we could all retire at 22, but and they have an income limit. Like I said before, it doesn't affect the income that they earn, doesn't affect the amount of their benefits, but if they earn over a certain amount, it does. So that's one that oftentimes, especially retired beneficiaries, don't really recognize that income limit as much as the individuals who are on disability. Another problem that we see are disabled adult children. They fail to report a marriage. That can affect, and also widows, if they remarry and they fail to report that can often have an effect on their entitlement to Title II benefits. So getting into some of those eligibility factors just as an overview, substantial gainful activity, like I said, is probably one of the most common. And what is substantial gainful activity? Well, there's a definition, right? Substantial work activity, and I've put those two definitions here of substantial and gainful. But most often, there's a dollar figure that Social Security is going to look at, and that's all they care about. Right? They say, okay, let me look at this person's earnings for this month. Is it over our SGA limit? And those are set every year. They go up with the cost of living. For next year, that limit for a non-blind individual is $1,350. For statutorily blind individuals, which is a very specific rule, they have a much higher earnings limit. But most commonly, you'll be dealing with the non-blind individual, which is a very low. For this year, I believe it was $1,310. And one thing I want to note here is that our clients will tell you, they're like, I worked under that amount. I worked under that amount. And it's really hard. And Social Security doesn't do a great job of explaining that these are gross wages, right? So be very clear when you're working with clients, that you ask them, what was the amount before taxes? What does it say before they took anything out of your paycheck? And even yesterday when I met with the client, my client was like, but that's not what I make. I'm like, I understand, but that's what they're going to use to determine whether you're working at a certain level. So just make sure you're really clarifying that with your clients. And it's really important to rather than to rely on a client's sort of own allegations, is to ask for this evidence, and it's what you'll ultimately need to try to challenge some of these overpayments in the first place. Like I said before, a lot of times these overpayments are in a far look back period, so the historical SGA limits will be very relevant to you, because if someone's coming to you with a 2015 overpayment, and it's for work activity, then you'll need to know what the SGA limits were in 2015. And I've included a link there that's in the PowerPoint. So what is not SGA work? There are some things that can either reduce the earnings that are considered that would be counted towards SGA work, and some earnings that just don't count as SGA work at all. Those are a little bit easier, things like bonus and incentive payments, and that's a very specific, you do need to read those. The bonuses have to be structured a certain way. It has to be just maybe like a holiday bonus. If it's bonus based on their like work output, so like maybe a sales bonus, that would be countable, but something like just giving a holiday bonus would not. Cafeteria plans and any earnings not directly related to your work activity. And that can be a little tricky, but once again, things that are just maybe a benefit of the employer should not be counted as earnings. So maybe like a gift card or payments that they win in a raffle, something of that nature. If it's just for working at that, or you just receive it as a staff member, that's not tied to your actual work output, that would not be countable. But the two most common ways that we deal with work activity to reduce what Social Security is counting are impairment-related work expenses and subsidies. So impairment-related work expenses can get pretty complex, but Social Security should deduct what we call, and you'll hear us call it IRWI, for SGA purposes when the item or service enables you to work, you need them because of your impairment, and you pay for the items and they're not reimbursed through another like health insurance, and the cost is reasonable. Obviously, you can't go, I don't know, pay $20,000 for a wheelchair that has features that aren't required for your impairment. So an example, John is earning $1,350, which is over the limit for this year, would be right at the limit for next year, a little questionable, but in gross wages. So his monthly copay for his medications that he needs, so maybe they are medications for his anxiety, and he has to have that to be able to go into work each day. The copay is $75, the rest is covered by Medicare. So when you reduce his benefits by the $75, dollar for dollar, his countable income would only be $1,275 when determining SGA. And so for the year of 2021, he would be under, 2022, he would be under. And I've included types of expenses and deductible examples and non-deductible examples for your reference. We don't need to go through all of those, but common things are service animals, prosthesis, the prescription drugs, certain devices can be. One case that I did, an individual had transportation modifications. So it was a device on her car that enabled her to drive. And those, could be pretty significant costs to reduce her income. I've also included a link to the Red Book, which kind of where I got most of this from, and that goes more in depth on these issues. But it's one of those things you just want to ask a client very generally. They're not going to think about this and in the setting like whether maybe their impairment doesn't allow them to drive. So do they need certain types of transportation to get there? That may be an expense that you could reduce their income by. Subsidies are a little bit more difficult to determine and to assess and get Social Security to apply. So a subsidy is a support provided by an employer that results in an individual receiving more pay than the actual value of his services performed. What does that mean? So it basically means that this person isn't able, person isn't able to work without accommodations and can't put out the same work output that a person without impairments would be able to do, is the way I would kind of describe that. And the way we typically quantify that, because it's very hard to quantify that, is by productivity level percentages. So there are actual forms that Social Security sends to employers that that employers often indicate this. Some of those may be in the file already, but there is also the ability for you to go back and contact this employer and say, you know, when this person worked for you, or this person who's working for you, are they able to do all the things that an employee without accommodations would be able to do, or just one of your typical employees? Have you had any issues with absenteeism, or, you know, reduced hours that you accommodate for this person, and finding a way to quantify that? And I'll show you what that looks like on the next screen. So an 821 is what a where they could indicate this. So an individual fills out, well, should fill out work activity reports when they're working, and they can note this. And I don't know how well you can read that, but they can indicate that they had extra help, that they worked irregular or fewer hours than other workers, that they were given special equipment, they took more rest periods than other workers, or they were given special transportation. This helps you identify some impairment related work expenses and subsidies. And this is one of those smoking guns, right? If they are counting in a person's entire amount of wages and they had a work activity report that indicated some of these things, you definitely have an argument that, look, this person was not engaging in substantial gainful activity because they told you about impairment related work expenses or subsidies that they were receiving on these jobs. So those are things that you want to think of, eligibility factors when you're working on a Title II overpayment. And then common causes for SSI are usually related to the means tested rules that you're dealing with. And some of these mirror some of like the continuing disability rules, but most of these are going to be related to the income or resource eligibility. So having too many resources, too much money in the bank, to a property that they didn't report, something of that nature, or being over income. So there might, you know, most of these that we've been talking about are the person's not entitled to that entire month of benefits. But with SSI, you could really have a reduction of benefits. So maybe they were working and they were truly making $800 gross a month, but when they estimated that for Social Security, they only said $600. So Social Security paid them, you know, a portion of that too much, and they want it back. And then there are also some eligibility rules that deal with living arrangement that often result in overpayments. So in-kind support, so they weren't paying their fair share of rent and utilities, someone was helping them. That may result in a reduction of their benefits. And then some of these other rules, like being outside the US for more than 30 days. You can't receive SSI when you were outside the US for more than 30 days. And a lot of people don't realize, you know, maybe they went on, they might be a citizen, but they're dual citizens and they go to their home country for a couple months to visit. They technically weren't eligible for SSI in that second month. The same goes for institutionalization for more than 30 days. So nursing home, prison, even like a psychiatric facility, you are not allowed to receive the full SSI amount if you've stayed in one of those facilities for over 30 days. And in some cases, like prison, you aren't allowed to receive any of those benefits. So to figure out whether Social Security is right about that, you have to know how to budget income for SSI. And I've provided that here. It's fairly easy once you kind of know it, but you've always got to refer back until you're really comfortable with this calculation. The first thing you have to look at is unearned income versus earned income. So the $20 disregard usually applies to unearned income. That would be what you apply it to first. If there is no unearned income, then you would apply it to earned income. For earned income, if the $20 disregard has already been used up, you then have a $65 disregard, and whatever's left over, they divide that in half, and that's what counts for wages. And I know that's not very complex, but it's one of those things you just kind of got to do the basic math problem and figure it out. So seeing it in practice might be a little bit easier. John is age 65. He lives alone and works part-time. He's earning $1,000 per month. So he doesn't have any unearned income, just earned income. So he's earning $1,000 We subtract the $20 disregard and the $65 disregard. So that's minus 85. That leaves us with $915. And we divide that in half. I've rounded up, 457. You subtract that from the maximum benefit. And so the only SSI he should receive is $326. So with Jane, Jane is disabled and lives alone. She receives a small SSDI benefit. So this is one of those dual eligibles that we talked about earlier. $320 per month, and works part-time, earning $505. So 320, you minus the 20, that leaves us with 300. Then she's got the earnings. So we've already used the $20 disregard. We can only use the $65 disregard here. So we subtract the 65, which leaves us with 440, and divide that by 2. So we've got to add those two together to determine her countable income, which is 520. So she should receive $274 in SSI. So when I spoke earlier about dual eligibles being eligible for the maximum SSI limit plus $20, so for instance, if Jane only received the unearned income of SSDI, then we would only reduce it, the amount, by $20. So it really gives her $794 plus 20 with the SSDI and the SSI together. So the resource limits are often a cause for issue in SSI. Like I said before, $2,000 for a single person. For married or a child who receives SSI with parents, that the limit is $3,000. Basically, the first of the month is what they look at. If they have $1 or more over the asset limit at that month, they are ineligible for the entire SSI benefit for that entire month. So that's where you can have, major issues. And also the first of the month rule is really important for people, because if the maybe they had a deposit, right, that came in the middle of the month. If the person's just looking at their balance and they're not looking at the first of the next month, then they might be applying that incorrectly. So remembering the first of the month rule is really important. There are some resources that don't count. The most common is that the home that you live in does not count. One automobile does not count. A life insurance policy worth $1,500 or less. And what I mean by a life insurance that's worth $1,500, the cash value. So this would not apply to like term life insurance policies that have no cash surrender value. And of course, if the cash surrender value is really low, then it wouldn't really, that they wouldn't count that. Burial plots and burial funds worth $1,500 or less. There is a burial plot and burial fund exclusion of $1,500. Money held in an ABLE account, which is a more complex issue for people who became disabled before 26. They can have a specific bank account that allows them to save money in it that that doesn't count for SSI, which is probably a little more complex than the type of cases we assign to pro bono attorneys, but it's something to be considered. And then one of the things that came out of COVID is that we were there's a lot of issues with resources, people being over resources for SSI, because now they've gotten stimulus checks and they're holding on to them, due to the uncertainty. So any COVID related financial assistance does not count in the resource calculation. And there are rules that they are supposed to presume that should anyone have received this money, that should be reduced first. So this can have really significant long-lasting effects for the resource limit, because for a certain amount of time, you're going to be able to say, if someone today has $4,000 in their bank account and they received all 3 stimulus checks, we could probably show that they're under 2,000, because they are to presume that the money over the amount is related to COVID financial assistance. So you got an overpayment, you assign a case. What do you do? So there's the appeal process or the waiver process. You can do either, or you can do both, actually. So some of the things we like to think about the appeal really is going to be a challenge to the merits of the overpayment. You disagree with the amount, or you disagree with the actual occurrence of the overpayment. A waiver is the equitable relief, right? This was not this person's fault and they can't afford to repay it back, as sort of the general rule to live by there. So it's your equitable relief. So you can always file at the same time, but you can also do a waiver at any time. So maybe you pursue the appeal and hold the waiver. And typically, even if you file at the same time, the offices can't do it all at the same time anyway, so they'll hold that waiver. But it's really going to be a determination of the merits. I would say that for this particular project, 9 times out of 10, the waiver is where this person is. They've either long past their appeal deadline, or the fact is that the earnings were over maybe, but they reported it to Social Security, and Social Security took 4 years to recognize it. So that's not their fault. That's something that you would probably, it's not worth an appeal, but the waiver would be a more adequate remedy. So talking a little bit about appeals quickly, because it's not the most common thing we deal with. It involves the merits, the fact, or the amount. And it's very important that when you file an appeal that you're clear about that. The rules allow field offices to construe appeals as waivers when they include language that tends to indicate a waiver. So don't use similar waiver defense language on an appeal. Don't say this was not their fault. Don't say they can't afford to pay this. That can really we see this all the time. People file it. That's what they said. They are really focused on, this is not my fault. And there could be legitimate appeal defenses, but it gets processed as a waiver because it was construed that way. So that's just a practice tip that I think is really important. So how do you appeal? When you've decided that the merits of the appeal, that you have arguments, you file, and you can always file, right? There's not, one of the things I think Doug said last year, there's no rule 11 right here. And we always tell people to file. Like, I would rather figure out later whether you have merit to your claim than you lose your appeal rights. So there is absolutely no harm in filing an appeal for Social Security and then figuring out what your arguments are after you've submitted that appeal. So the form that you do that on for the first level appeal, which is called a request for reconsideration, is an SSA 561. I've also linked the non-medical online appeal form that we have, that Social Security has now. And what does this do for recoupment? So that's always the most important. When we file an appeal or a waiver, we want to do it as timely as possible, because it can have an immediate effect on whether Social Security starts taking this overpayment out of their benefits, recouping it. So if filed within 30 days of the notice, recoupment never starts until the appeal is resolved. If you wait after that 30 days, they will stop it, but the recipient is at risk of potentially having recoupment for 1 month, just because processing times, getting that keyed in, maybe even 2 months, depending on when you file it. So if you're unsuccessful at a reconsideration, the next step is to get before an ALJ, and that's a request for hearing. That's done on an HA 501 or online. And one thing that I always like to remind people is that there are rules for evidence submission. It is a de novo hearing. You can submit any new evidence you want to submit, but you have to do it at least 5 business days before a hearing. Finally, if you're unsuccessful at a hearing, you can request appeals counsel review for errors of law or substantial evidence arguments, and that's done on an HA 520. No new evidence is allowed to be submitted, and there's not a new hearing here. No new evidence, at least without good cause, which is has a very specific. So that's the process for overpayment, and you really just have to sort of review the eligibility rules to determine whether the merits of the overpayment exist. But for waivers, you're going to look more at this equitable argument, like I said. So the waiver is requested is a request to forgive the overpayment. You're not necessarily disputing the occurrence of the overpayment, although you can use that as an argument for that it's not an individual's fault. But there are also other equitable arguments that can be made. Like I said, waiver can be requested at any time, even if they've already recouped the whole overpayment. This is a little bit more difficult in Title II, but in Title 16, any overpayment that has been waived any recoupment that has happened must be reimbursed to the SSI recipient. Prior waiver denial is not a bar if you can show circumstances changed or there's new evidence. So, and when I say a prior waiver denial, it's really important that that prior waiver denial was for this particular overpayment that you're talking about. It does make it a little more difficult in cases when people have had multiple requests for a waiver, whether they've been denied or granted, because oftentimes arguments rely on someone understanding the rules. And so that can make it more difficult, but there are definitely arguments to be made for why someone should get a waiver, even if they've had a prior waiver or they've been denied a prior waiver. An entire overpayment can be waived, not just the amount due. So if like I said, if someone has already paid $1,000 on it and they still owe $5,000, you can get the full $6,000 waived and request those refunds. What do you have to prove? So this is the basic overarching rule. The person has to be without fault. Now, without fault can be made through a variety of arguments, and we'll go into those, but they also have to show that recovery would defeat the purpose of the act, which is basically interpreted as they cannot afford to repay, or recovery would be against equity and good conscience, which is really that truly equitable argument. So, but has a very not a very open definition. It's pretty narrow. So common arguments that we have for without is that maybe this person had a payee. So they were under the age of 18, or they, at the time that they were entitled to benefits, they were appointed a payee due to mental health issues. And that payee has the financial responsibility for helping report things like work activity and things of that nature. And this is often a really easy way to get an overpayment waived for an individual. A really important practice point here is that you cannot or should not generally represent both the individual and the payee in that circumstance. So unless you've already had the overpayment waived as to the individual, working with the payee at that point may be okay, but you would probably want to get that the potential conflict waived. It's just something we try to avoid when we can. But oftentimes with children and parents, it's sort of a package deal, and so we do handle those. Overpayment, another common argument is that the overpayment was incurred by someone else drawing benefits on the same record. What do we mean by that? So maybe you had a survivor's case where a child was receiving and then another child filed, he had another child with, he or she had another child, and they get added to the record. Well, now that whole benefit has to be reduced and divided by 2, essentially. So they might have gotten overpaid. That's something you can clearly was not the fault of that child, that another child was entitled on that record. Another example of that might be maybe a spouse is drawing, but then a child becomes eligible, like a disabled adult child, and is drawing on the record. We've had some of those cases where it just then reduces everybody's benefit across the board. And this is a little bit less successful, but maybe they relied on someone else in their home, but they weren't technically appointed a payee, but an ex-spouse was managing all the affairs, and they reasonably relied on that person to do these things. Oftentimes, the beneficiaries themselves are following the rules. So they've reported this income, they have proof, they called, they've faxed, they've dropped it off, whatever. And Social Security just took 5 years to process it. And that happens quite a bit. It's always hard to get the evidence to prove that it happened, but we have, you can find things in the file that indicate this. And, and of course, testimony is allowed in these conferences. So And these are just kind of keep on going. One that we really, you want to definitely dive into is someone who fails to understand. So if you have evidence of a mental or intellectual impairment, that needs to be explored, and how well they understood these rules and how well they were explained to them. It has to be a reasonable misunderstanding. So to that point, if someone's had multiple overpayments, at that point, they've sort of been informed of these rules several times. So this argument gets a little weak for that type of, in that situation. And these are listed. I don't want to take up too much time just going over these. You can kind of refer back. And then one thing that's, if we probably wouldn't have to, I hope that we would never have to assign this type of overpayment out for assistance, as the office should process these automatically at the Social Security Administration, but an overpayment under $1,000 is something that just gets administrative waiver usually. So defeating the purpose and inability to repay. So the first thing I just want to talk about is someone who is receiving SSI or other public assistance is automatically presumed to repay. And when you're filling out the SSA 632, there's a little box that a lot of people miss before Section 2 that says, are you in receipt of SSI? And people will check that, but they don't read the parentheses after that says, skip on to Section 3 and sign the application. You do not have to fill out the financial portion if this person is in receipt of these benefits. You don't even have to go through all the financial considerations. It's presumed. You don't need to provide receipts. You don't need to do any of that. So it's really important to read that form carefully when filling it out for individuals. And showing that so for Title II recipients, it's not presumed. So you always have to provide this information. And that is that the person is basically showing that the income they have, both theirs and their spouses, if that's relevant, the income that they have is exceeded or is balanced out by their monthly expenses. So that you have to you're basically trying to get your balance sheet to zero, right? Or negative in this situation to show this person cannot afford to pay this money back. And you have to provide receipts. You can file the form without those, but they will be required as evidence within 30 days usually. And it's important that you do have to provide the income expenses of the spouse and the parent, but likewise the expenses should be in there as well if you're having to count the spouse's income. So against equity and good conscience. So this is pretty limited. This is the program and operation manual system, which is going to be sort of your lifeline when you're doing these cases. It's what the workers at the local office use to determine these cases. And so everything I'm saying here today can be found there. Well, mostly all of it, but that's going to be really where you need to look into these things. So certain, that's just an equitable argument that you have to make. But it's, I don't want to say it's limited. They obviously, and especially when you're at the lower levels, right? That's an argument that is a little more suited for judges than it is for your local office. They just don't find anything to be inequitable, and that's just the practical matter. So it's something to make, but it's definitely usually not something we want to rely on. I would open up to anybody who works with me to say whether they've ever seen it applied, but usually you're still going to want to show that someone truly can't afford it. If they have $20,000 in the bank, it's going to be really hard to prove a case. So waiver of overpayment, another really important point is that there is this automatic administrative waiver of overpayments that were incurred during the COVID emergency. This is very specific to overpayments that were incurred between March and September 30th of 2020. That's the only period that's covered. So they can be requested orally. You don't even have to put it on a 632, although we recommend that if you're helping someone that you do. And of course, it doesn't apply to people, overpayments that were a result of fraud. And I've linked the internal instructions. So these instructions were kind of like a mystery to everyone. How do you do this? How does this apply? And finally, under the Public Records Act, we were able to get redacted copies of this. So I've linked that there. It kind of just walks you through that process of how this applies. But it's one of those things to look at. If a period of the overpayment occurred during the March to September, you definitely want to make that argument that at the very least, this portion of the overpayment should be waived. So when you file, the 632 is the first thing, and you're going to wait on a decision, right? So when you wait on that decision, then you have the right to a personal conference. So you're going to get ability to sort of meet with somebody and talk about that, but they have to give you the right, or you have the right to review the folder before you do that. So this has been challenging during the pandemic, and I think anybody who's taken a case could tell you that for a while they were like, well, we just can't process these because we can't, all overpayment records are paper. And so, and you can't come into the office. That's absolutely not happening. So now they have made a process where they can send you an electronic file, but it's often missing things. So it's one of those things that, you know, you're going to have to review it to the best of your ability, but asking your client to provide documents and just kind of learning what's in a folder typically. And I've provided a next slide that I'm not going to list through, but just things to look for that may be relevant to your case that aren't there, that are there or aren't there. So you want to review that folder. Outside the pandemic, we actually had to physically go into the office and copy the file on a copy machine. What are those? So this is a list of documents to look for. I won't go through that. It's call me if you have any questions about whether it might apply in your case, but it's one of those things to just use as a reference. So when you go to the personal conference, this isn't your first chance to argue a case, basically. And you want to do that as best you can, but remembering that this is a local office and they, you know, operate within very small confines of what they perceive the rules to be. I think Todd took a case and I told him, treat this like a discovery conference, right? Like you just want to find out what they know that you don't know, because oftentimes this is not going to be where you're successful. You know, most Social Security cases, we tell people you're going to have to get to a judge before you can have any sort of confidence in your case. So this is really a time to make those arguments, and definitely the sympathetic arguments you can make, but also to ask questions of the worker and get additional information, and resist the urge of the worker to make this person drop the waiver and enter into a repayment plan. You are this person absolutely has the right to a waiver decision on this personal conference, and then to work on a repayment plan. So make sure you don't give in to that tactic. You can appeal. So after the personal conference, you'll get a decision and you have the right to appeal. So there is a sort of split process for SSI and SSDI. Technically, for SSI cases, you have the right to another reconsideration of that personal conference decision. So this, and it only applies to SSI. It does not apply to RSDI Title II cases. You can request reconsideration if you want to. If you ask for an ALJ hearing, they will process it. Even though the rules technically say this is the next step, they will process it. In fact, every time we file a request for reconsideration on this, they call us and tell us, you filed the wrong form. It's supposed to be an ALJ hearing, at which time I have to send them the POMs that says this is the rule. So it's one of those things, kind of just balance out. Would your client have a better chance at another conference, or whether you want to move straight to an ALJ hearing? So that's only for SSI cases. If you lose that recon, again, the next step is an ALJ hearing. And for Title II cases, you move directly from the personal conference to an ALJ. And you also have the right to appeals counsel review. So the things that I want to focus on most, and I've talked forever and I always do this, but is how to actually manage these cases. The first matter is, if you're going to represent someone, you have to file a 1696 with the Social Security Administration. This gives you the right to communicate on their case, obviously make some decisions, as needed with the input of your client, and really just to be able to cut off the long phone calls with a client on the line. So you have to do this right away when you have decided you're going to take a case. And it allows you to use some of the tips I'm going to tell you about that you wouldn't have the benefit of using. You want to make sure you withdraw this after you have closed a case or you're no longer assisting. And we talked a little bit about avoiding conflicts, but after you file a waiver, this is all about persistence, and even an appeal, really. These are just sitting at in some black hole at Social Security. So you want to make sure you're following up. And I'm not saying you have to call every day, but I am saying you want to put a tickler on your calendar and call every month and, just check in. First and foremost is that you want to call, about a week after, because it's very possible that for whatever reason, your information never got scanned in and processed. So we want to make sure that they've received it, that it's being worked, and that it's being assigned to someone. And when you're working with those dual eligibles and you're at the personal conference stage, you want to make sure they're showing you both folders, because you'll get an SSI worker who's going to be like, well, this is an SSI overpayment. Well, there might be information in that SSDI file that helps your SSI overpayment case. So make sure you're being mindful of that. They will be mind blown. They can't, like, those two sides just can't communicate. So you really have to fight for that. Practical tip, these can be evaluated for bankruptcy after, but that's something you can send back to our office for evaluation. So contacting, this is what I really want to talk about. And I've provided Charlotte Social Security office and Concord office, because certain zip codes in Charlotte go to the Concord office because Charlotte Social Security office is so overwhelmed. But the main thing I want to show you here is this admin line. If you have filed a 1696, you can call the admin line to sort of initiate the conversation with whoever is assigned to your case. So if you're having a hard time getting through the main line, you can't get your work, or maybe you have been assigned and you've been trying to contact this worker, you've left 18 messages to no return, your nuclear option is to call the admin line and say, look, I have been working with such and such, I haven't received a return call, and this is going to have a supervisor on the line who can at least potentially answer some questions or get someone to call you back. You cannot have the client on the phone for this option, however. So this is only for attorneys to communicate with Social Security office. So that is something you want to use to establish the relationship or to follow up on the relationship when they're not holding up their end of the bargain. Here's Concord's information. They also have an admin line. Concord, you can only pray that you get a case in these zip codes, because they are a much smaller office and have much more capacity to work cases and process cases correctly. So we don't have as many problems, I would say, with the Concord office. And a fun fact is that Heather Banker, who is a managing attorney of Legal Aid's husband, is one of the main supervisors there. And so I feel like we get a little bit more like love out of that office. So I've also provided the regulations and the POMs here for you. We're running out of time. And I want to open it up for questions if you have time. But the one thing I want to tell you is that these cases are so hard for individuals to manage right now. With the office being closed, it's just gotten 10 times worse than it already was. And these workers can be very intimidating, and they give misinformation. So it's really, really important for you to deal with Social Security with confidence, even if you don't have, even if you feel like you don't know anything, act like you know it, right? Fake it till you make it, because they will try to intimidate even attorneys. And it's really important that you hold their feet to the fire. At this point, it's so important that I encourage you, where you aren't having any movement in your cases. We've gotten our a client's congressional representatives involved. There is a regional communications director for our region that we've gotten involved. We need you to be the ones with passion to take these cases and really force Social Security to do their job. We do it every day, and they're tired of hearing our names and our and our arguments. So I really want to just encourage you to understand how difficult this can make individuals' lives and how complex it is. A lot of it's math, a lot of it's, things that we don't like dealing with. So you can imagine for an elderly or disabled individual how complex this is and how frustrating it can be. So I will open it up for questions. I want to go ahead and tell you, if you do have to log off, that your CLE code is Waiver in all caps. So let me go there really quickly. That is your CLE code if you need to log off, but I will remain on here for a little while if anyone has any questions. We also have my contact information there if you'd like to reach out to me after, and also the person who probably could have taught the CLE 10 times better, Nan Allison, who's a paralegal advocate who handles these cases frequently. She is also, her contact information is here. But does anyone have any questions that they'd like me to answer? Just there's only like 13 of us on here, so feel free to reach out. And can you unmute? I don't know. Raise your hand if you can't.
Cassidy, this is Jewel. Oh, Todd. Hey, go ahead.
No, I was sorry. I was just going to say that Cassidy was incredibly helpful in the case that I took, and so I would just say that if you do get into one of these and it's more complicated than you think it is, the backup and support I got from Cassidy and from Laureen and making sure that I could get my client what they needed was terrific. So feel safe and feel comfortable. Be confident because you're going to have the resources that you need to take one of these.
Absolutely. I'm happy to answer any questions. And if I can't do it, I'll assign someone else to sort of talk through it. I mean, oftentimes, even in our office, we got to talk through these cases because the files are so complex or not at all complex. So you have nothing to go off of. And so it's often, it's very helpful to bounce ideas in these cases off of multiple people. So feel free to do that. And then also your champions are starting, I hope Allie and Matt are starting to feel like they've got a little confidence in this area. Reach out to them as well. Todd has done one. They can be really helpful in doing these as well. Anyone else?
Actually, I have a quick question. Can you hear me? This is James Fetter. I'm Nelson Mullins. So if someone has already started repaying on a repayment plan, does that mean that they can no longer file for a waiver of any sort? Or can they say, wait a second, like I figured out that X and Y conditions apply now. I didn't know that. Y'all didn't tell me that, that sort of thing. Or if they hit hard times, that they can go back and say, hey, wait a minute, I was repaying, but now I can't.
Absolutely. And in fact, that's how most, obviously when you get hit with a letter that says you're not going to get paid for 2 years, your first thought is not, let me get this forgiven. You're like, I can't pay that much, right? I can't pay that much. So we often get people who are already on payment plans. One of the trickier things that we talked about is whether that payment plan came out of a waiver denial or whether they actually just entered into a payment plan. So that can be a tricky thing to try to figure out from the file. But I mean, like I said, I'm one of those people who will just like fight a battle till it can't be fought anymore. It can be more difficult if they've already had a waiver denial, but you need if you have new evidence or even just a change of circumstances, you can definitely try to get that through. Probably won't happen at the earlier stages. Probably just go on up to the ALJ in that situation and make really strong arguments. But because the field offices just aren't gonna do it. I don't know how else to explain it. They have very little sympathy for overpayments, and the easier they can get them off of their desk, the better. So when you're dealing with a little bit more complex issue where there may have been a waiver denial and now a payment plan, but now you're going back and filing a new waiver, I would say that most often you're going to want to be at a hearing to resolve that, at a real hearing, not a personal conference, a hearing with a judge. It's just a better forum to make some legal arguments and even those equitable arguments. Anyone else? Well, thank you so much for being here today. I do want to, I hope that everyone will take a case. We have plenty queued up and ready to go. So I will be reaching out, and your champions will be reaching out soon to try to get everyone involved and have people involved in these cases. So I appreciate you attending. If you have any questions, please let me know. Feel free to email me or call me, and I'll leave the code word one more time up here for you so you can make sure you get those forms. And on the form is Juanita's information is on there, so you can just follow the form. I believe Brandy attached it to everyone's invite, so you should be able to get that form there. Thank you so much.